You're watching The Daily Report. Welcome back. The conversation just getting heated on air and off air with my guests, Ishmael Nyaribo, the Honorable Beatrice Elachi, and Joshua Kiptoo. Before we went on a break, again, you wanted to, remedy and recommend how we should be interpreting the law.
No, you see, really the main issue is we are all in one house called the Kenyan Constitution and the sovereignty of the people. Whatever semantics we give it, at the end of the day, whether we have to wait for the Senate to interrogate this matter, whether the Senate would be asking, should the Deputy President have been subjected to questions in Parliament before the question was put to the public, for public participation, or the Deputy President should have been tried in the National Assembly first, then the question carried to the people.
Because he said on TV he was not given a chance to be heard. Yeah,
and then here you hear members of Parliament are saying he should not have come on air on Sunday evening, I believe.
Monday.
That was Monday in the evening, before the next day when he was being crucified, quote unquote. So what comes first? I mean, this is what the courts will be interested in, and like the honorable member here is saying, it is true that this is a learning process, and my colleague is saying it's a moving target. It is true. The question of public participation, by the way, is not young in this country. The only problem is that the members of Parliament have not enacted the specific law to control, to guide rather the public participation. But what comes first will be considered. All I am saying is that in the Senate must exhibit the maturity they have shown in the Kericho impeachment today. So that in as much as this is a political contest really, you must remember that you have Kenyans you are carrying the country on your shoulders. You can drop it down or actually take it to a safe place. You can decide, okay, the head of state may not like Gachagua, and many politicians don't like Gachagua, but the people who finally elected him are 7+ million. He may have his own dirty, linen. He may have his own problems. What are we going to do with the Kenyans who actually voted for him and still like him? So that is, for me, the main issue. It's not a question of politicians have ganged up and it's a political process and they are going to annihilate him in the Senate. That's not the question here. And by the way, the Senate, again, we all agree, is a trial chamber.
Okay.
So the question of it's political, it's not a slide downwards the hill, down the hill. It is inquisitive, approach. We are putting this to the Deputy President. What is his answer? We are putting this other one. What is? Then the Senate should be asked, each member, are you voting from 1 to 11? Which one are you agreeing with? You could be surprised that 6 charges might be proved, but not that all the 47 or 67 members of the Senate are actually proving that. So the guy might actually get off the hook.
In terms of precedents, when you look at how this has been addressed, are you even worried as legislators that perhaps this could even happen in your case? Because there are pundits and other politicians who have argued across the divide that this could be happening to the DP, but it could also befall the same members of Parliament.
Yeah, but we have no process of impeachment.
Yeah.
It is
recall.
It is a recall.
We call recall.
And it can happen. That is why all these articles are there.
Okay.
I thought we put them in knowing very well that at one point it might find me or another person.
Okay.
Yes, because I have also gone through an impeachment.
Yes.
So it's a matter of you wait for that process, then you just go to court. But for this one, you see these other impeachments, even for the governor, there is no clear framework. It's impeachment from the county assembly, you come. But then let me say this. As I said when we started and went through public participation, yes, the question was the 11, you explained them, but they are very clear. I think the best the Senate will do is first do sort of like a pre-chamber
pre-trial
to agree on what is admissible and what is not.
They did that.
And so if they've done that, it means they've narrowed down. Now we've gone to the real charges. Now we are not spreading to the 11.
Absolutely.
Now you have clustered them based of gross violation, violation of the Constitution, Chapter 6. Now I think we are in that context now. I believe, having been in the Senate, he will be given the lawyers, everyone. But he will also expect the same way when you're in court. Questions will come in many angles even. I think he needs to look at the impeachment of the deputy governor of Kisii.
Mm-hmm.
That will help him to understand that when you're in such a scenario, and the Senate is now, the Senate will look at anything that you have ever done of gross violation of the Constitution, of Chapter 6. So it's up to him to look and realize the same way you normally go to court and a lawyer will take you to another journey where you were not even expecting. It's the same way. So for me, and then in terms of looking at the same public participation, you remember in some parts they refused to go for public participation, which was very wrong. They needed to have gone to public participation and bring in the forms saying, we don't agree. And you must go back now to the ruling of Maringa when he did the nullification. Remember, he took us back to the ballot. And when people, those who rejected to go back to the ballot, Maringa said, we gave you an opportunity. You yourselves refused to go. So all those rulings are there to remind them, if you come in with the process of public participation, it was not done right. Yet in your own backyard, you decided not to do that public participation so that you bring in the numbers to say no. Then again, it will be questionable. Then you might find yourself also in more crisis, thinking it was not the issue of threshold, but it will be the issue, your own people did not do that public participation to give their views in terms of what they feel is wrong. And so I would wish, and as I said, it is a process where we are looking at, we are learning, but I know the Senate will do justice to the process. Whatever verdict that comes, at least Kenyans will have understood why is it that it will go this way or this way. Even Kenyans maybe will, Kenyans are very good in starting to participate when they realize, and that's what they did with the impeachment of the deputy governor of Kisii. They realized, you did this. They started now participating. You could feel now Kenyans becoming more angry. So I'm hoping it will not elicit to anger where Kenyans also will feel very angry in the whole process. Either way.
I think the public participation, I just want to compliment something she mentioned about people refusing. I feel that protest is a form of public participation. Why? They protested. Some tore down the papers to express their disgust and refusal to agree to the impeachment itself. Then ultimately, the parliamentary staff, I could see, were bringing more documents. And at the end of the day, they still sign. And you could see the results that were tabled before the National Assembly, where in those areas you could see 97%, 100%. I saw for Mukurweini, the MP was touting how in his constituency with 3,000 that attended, 100% said no. So I never wish to ascribe how people should behave. I have personally been a champion of public participation and I've attended them to the point that one, you never dictate the reaction of the people. You can only focus them on the issue, but you cannot dictate how they respond, how they react. Let them be. Let them express themselves. And in the same public participation, you're also able to gauge public mood, which for us, you tick a box for knowing what the people want. And that's why, for example, from the public participation that happened, two messages were clear. Yes, we agree with the impeachment of the deputy president, but he's not alone. That was more or less a common messaging, where they were saying, we need to see this wholesomely. And then it was the duty of the parliamentarians to come back to them and tell them that's okay. If you want to remove both of them, no problem. But the process that is before us right now is for one of them. So let us deal with this one. Anyone can come with an impeachment, for example, for the president, then we'll come back to you. So you focus them, but you don't forget to take their concern. You don't forget to get their reaction raw. Don't dictate. It's not a classroom. Let them be. Let them express. As long as there's no violence, you are good to go. Importantly, the reason why we keep saying Senate is mature and Senate will do a better job is simply because of the fact that Senate is smaller than the National Assembly. You have 67 members. National Assembly is almost 6 times the number. 349 MPs. What time will you have to have comments from all those MPs? And these are learned people. These are Waheshimiwas. And Waheshimiwa, by virtue they were elected, it shows they are opinionated. I kid you not, every 3349 member of that house has a comment to make. Whether in proper English or in Kiswahili, they are sure to express themselves. That's why they were elected, and that's why they are representative. So with 349, it's a huge crowd for you to get ample time to prosecute to the detail. That's why you could see the National Assembly Speaker was struggling to give even the move of the motion, say 30 minutes. And then the move of the motion was forced then to donate and say, I give MP Kaluma 10 minutes, I give Otienda Amolo 5 minutes, to try spread it out, say, I only need my 10 minutes. Now, Senate has one advantage. The numbers are minimal. And number two, it's a trial chamber not considering a motion. Parliament was basically to consider a motion of whether to adopt or to reject. Okay. Now, Senate is to conduct proper trial, and that's why there's cross-examination. Look at the issue today. They started with the PO, preliminary objection, whether the threshold was met for the impeachment of the Governor Kericho. And that was given 2-hour period. Senators were given time to ventilate, then it went to a vote. So issue by issue. Unlike the National Assembly where they blanketly had to affirm or reject the entire motion, in the Senate, it will be one charge after the other. Then remember, a threshold for impeachment, one charge is enough to take you home. You can survive 10 out of 11. But one is enough to convict you. That's another red herring people need to see. Okay. So the defense of the deputy president is up against the wall to ensure they seek complete dismantling of 11 out of 11. Because if Senate agrees with let me assume the defense does a good job and acquits him 8 out of 11. What happens to the other 3? Still voted for, and if he fails in one single vote and the threshold is met of 2/3, game over. And that's how it is going to be. Yeah. So today I was impressed by the manner of the thoroughness of the team, of the defense team. They came, it reminded me of when Azimio were taking their truckloads of evidence to Supreme Court. Something similar happened today in the evening. If you saw the deputy president's team came with boxes and boxes of evidence. I'm just concerned about the timing. At least Supreme Court had around 21 days to listen through the submissions, sum them up. Senate has already done pre-trial. They've already agreed on the methodology where they're saying it's not going to be committee, it will be the entire house. Number 2, they've already allocated time. Number 3, they have even given the whatever the prosecution, timeline specifics, you have the defense. So the evidence may be for the purposes of optics and maybe to make reference to documents. So you would find that the National Assembly team, who will be the prosecutors, will also have to come absolutely prepared, and Senate now gives them ample time. So with this, the advantage of Senate is the numbers are less. Number 2, it's a proper trial like a court process. That gives it. So I am sure with that, Nyaribo will be comfortable that the process has been done. But ultimately, do you know what matters? Ultimately, it will be subjected to a vote. It will boil down to aye and nay. And that's what will matter. No one will bother about the arguments.
Yes. I think 2 things. One, the Senate is mature. I must repeat this and must be very, really it must get home that Senate is not the kind of chamber you throw in stuff and try to see what works and what doesn't work. They have lived that experience through how they have handled impeachments from the counties, and they bring the governor over there, and the MCAs are extremely excited, and they have the numbers, and then it reaches over there, and then they give the governor the chance, the same way they give the MCS the chance. So, and then they actually, MCS get surprised that, we came to the trial chamber with 31 members of parliament, but the law provides for 32. So what can we do? There is no way the Senate can squeeze in an extra member. And I believe when my brother is talking about time, by the way, this is a very serious issue, even in the courts. Are you prosecuting time or a substantive motion, a substantive issue? Yes. So now the Senate has given time frames for, discharging their mandate. Then here is evidence that has been brought in. Of course, say, like in the Raila case, there was evidence that was brought at the last minute and it was rejected. But this particular one, what is going to prevent you from admitting this evidence? Is it because of time, or it is because it is irrelevant type of evidence? So we must be cautious when we talk about prosecuting a case, and then we are completely consummated in the time frame and actually leave out the substrum, the real issues, that are supposed to be handled by a Senate. So for me, if the Senate is able to look at the evidence, that's fair enough. But in terms of how they will look at all the charges, my brother said, yes, if you fail in one. How do you fail in one? You fail in one if the two-thirds majority actually vote for that one. So about, 40 members might actually vote for count 6 goes through, and, with the 44 people. But in count 5, you only have 32. And yet in count 9, you have 50 for that matter. So still, the ones who have voted here in the 50 have not voted. So it is not an easy walk in the Senate. And like Honorable Beatrice said, Kisii deputy governor, by the way, that's a classic example, isn't it? In cross-examination, they will want to see how the deputy president handled his brother's family. They would want to see. But in the end, there is a charge sheet. All the arguments must be pegged to the charges before the Senate. Okay. These other behavior that he was involved in, these, like you saw the Kericho governor one, like, I don't know, this and that, some funny other, allegations. Do they fit in or they don't fit in? If they don't fit in, they definitely are offside.
Mheshimiwa, the Deputy President yesterday in Embu hinted at, exploring legal options after the, whichever way it goes. In his words, he said he believes in the courts. And here we are dealing with two situations: the current, the petitions right now, and those that, he alluded to that would happen afterwards. Does he have legal options in the courts after whatever happens in the Senate?
Well, he has, but you see, the whole process also, the courts will look at what does the Constitution in principle give us time frame. So they cannot exceed the 60 days. In all this, they cannot. They have to be within that, unless they want to now open, and they can exceed, but then they will not put it at status quo. So this other process will continue, and for you, you'll continue with your process in court. But you should know there will be already another deputy president as you continue with this.
So where does that leave,
that is why it's important. I believe he has a very good legal team. They have to look at all those issues. Yes, they have to. But in terms of principle of the Constitution, that's what the courts, because they are the interpreters of the same Constitution. They will follow that. But they will not deny him to proceed with his face to look for justice. But he has to really know it is within that time frame that he has been given that. Yeah.
All right.
I think the deputy president needs to make a hard decision.
Yeah.
Why I say so? Because the window is closing fast. There's something about impeachments that come with finality. Once you are impeached, it doesn't matter what you do. You've seen what has befallen very solid leaders who've been impeached. Despite their political capital, they are literally impotent politically. There's nothing they can do. You have former Governor Sonko, you have former Governor Kiambu Waititu. These are more or less asset, politically speaking. They can be part of your team. They can help you mobilize, and I'm sure you know their capability and capacity. But to what end? And voters are very decisive in the sense that if they want to follow, for example, Honorable Beatrice, it's because they are going to vote for her or against her. If you are not in the ballot, then that comes to a cropper. So for me, I feel it's now time beyond these discussions of fairness or unfairness. I would want the deputy president to leave this conversation to his lawyers, purely to argue these points that we are arguing here about fairness or unfairness. However, he then needs to move a step further, sit with his political and whether you call it spiritual friends, and see the two options. One option: resign before the impeachment is finalized. But resign with a half in a way you create a lot of capital out of it. You have a fighting chance in the future. You never know how that can spin off to something. That's one. Number two, the idea of relying on court, it's a give and take. So far, so good. If I'm the deputy president, how comes I've lost all the cases that have come to court? Because the legislature is also working very hard to ensure compliance. In fact, when Parliament was given an order that same Friday, when the leaders were already in the field, it was at around 1:30 p.m. Everyone assumed that the executive and the parliament will come at judiciary and go file an objection seeking suspension of those orders. What did they do? In record 1 hour, they gazetted that, fine, we are going to comply to the letter. Tomorrow, Saturday, we are going to do at the constituency level. And let me tell you the beauty about it. Do you know in that space, court and parliament created a new threshold that we are talking about here? Now there's a threshold of public participation by legislatures. Now we know if you want to do public participation, it is at the constituency level. And Parliament now will have to follow that because courts have affirmed and themselves they did it and it worked. So for me, the deputy president then has to make that hard decision of whether to resign before then. Number two, if it is to rely on courts, it's a chancing game and the courts basically interpret. One question I saw is that, do the court have ability to interfere? They cannot interfere. The courts do not interfere, and they're not wishing to interfere. They have made it clear. Even if you saw the judge recusing himself and asking the Chief Justice to constitute a panel of 3 because of the weighty nature of this matter, why were they doing that? Because they know the magnitude and and how important this is in the architecture of governance. So, for me, I would then say, the courts only offer reprieve if the process is impugned. So far, so good. National Assembly has taken a major milestone in the sense of public participation, and by virtue the courts haven't issued any orders, it should be a telltale sign to the Deputy President, His Excellency Rigathi, that it's time to make hard political decisions. One of it, don't allow your die to be cast with impeachment, unless you have the numbers.
Let's take a break, and then when we come back, we also, I come back with also the issue that, Mheshimiwa Elachi, there are even names that are being proposed for his supposed
But this unfair advice to the deputy president should not go unchallenged, but we will wait when
we come back.
It's a very fair political advice. It's a realistic advice.
Well, the lawyers will say unfair because all of them are lined up in a business
to be paid for the process.
To do work.
Yeah,
and when we come,
which is still good for the constitution or for the country, because from this process we are putting into practice. I've told you a provision that no one imagined it would come to force.
Maringa, I'm not representing the deputy president, and he's not like my friend, so I am just giving a honest political advice.
Mine is unsolicited political advice. At the end of the day, he has to make a political decision. To what end?
Let's take a break. When we come back, we continue with this discussion. We can see your questions and comments. You'll also be throwing them to our panelists. Stay with us.